Let me welcome everyone today to the first of a series of programs on Utah water law, sponsored jointly by the Wallace Stegner Center and the National Audubon Society, to whom we're indebted for their financial support of this series. I will proceed with the introduction, and I apologize both to those in the room and to those who are online that we're a few minutes late getting started. We're dealing with a technical issue. I think it'll be fixed by the time I conclude my introduction, so I will proceed with that. I'm Bob Kiter, Director of the Wallace Stegner Center for Land Resources and the Environment here at the University of Utah S.J. Quinney College of Law. And again, it's my pleasure to welcome everyone, both in person and virtually, to this program. Let me begin with our native lands acknowledgement. We acknowledge that this land, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples and their traditional homelands. We respect the sovereign relationship between the tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. Let me mention some future events. As I mentioned, this is the first of a four-part series on Utah water law. On February 2nd, I believe 2 weeks from now, we'll hear about the Colorado River crisis or opportunity from Amy Haas, the Executive Director of the Colorado River Authority of Utah. On February 16th, a couple of weeks after that, we will hear from Rick Malloy, the Water Conservation Manager for the Central Utah Water Conservancy District, addressing measuring water use, the good, the bad, and the ugly. And then on March 2nd, we'll address considering wildlife in water management. Yvette Converse, who's Chief of Science and Resources now for Grand Teton National Park for the Park Service, but until just recently was the field supervisor for Utah Ecological Services Field Office of the U.S. Fish and Wildlife Service. All of these Utah water law programs are intended, in essence, in large part as a lead-in to the Stegner Center's 28th annual symposium scheduled for March 16th and 17th that will address the future of the Great Salt Lake. And I don't have to embellish that by telling you that the future is in some jeopardy at the moment. And we hope to address the root of the problems and potential solutions. I should add that our speakers include a number of scientists who are quite conversant about the Great Salt Lake, but we'll also include Governor Spencer Cox and House Speaker Brad Wilson. A couple of other Stegner Center programs scheduled for this semester. On March 27th, we'll host Natalie Coach, who's the author and professor of geography and environment at the Syracuse University Maxwell School of Citizenship and Public Affairs. The relevance of her work is a book that she has just published entitled Arid Empires, The Entangled Fates of Arizona and Arabia, talking about water issues in the American Southwest and comparing them, tying them to the Middle East. On April 6th, we'll hear from Professor Andrew Guilford, a history and environmental studies professor at Fort Lewis College in Durango, who will talk about his recently published book, Bear's Ears, Landscape of Refuge and Resistance. And then on April 11th, Ann Palmer, who has been affiliated with the University of Utah before moving to California, will address some letters that she discovered in archives that involve corresponding with the young Wallace Stegner. So we'll get a different sort of introduction to Wallace Stegner. So today we'll hear from Emily Lewis, who's the director and shareholder and co-chair of the Natural Resources and Water Law Practice Group with the Clyde, Snow, and Sessions law firm. She will address Western Water Law 101, not broken and ready to meet the moment. She has practiced widely in the area of water law throughout her career, which now is, 15 years since graduation, give or take a little bit, and involved a stint at the Utah Attorney General's office before moving into private practice. I should note, and we have it up on the screen now, and we'll put it up at the conclusion of Emily's talk, that we'll have a question and answer session, and you'll be able to join us by following the instructions on the screen with your mobile device. I won't bother to introduce the talk because we're going to hear it in a moment from Emily. But we really appreciate her joining us today and leading off this series of discussions about Utah water law. And we're anxious to hear how it's ready to meet the moment. So please join me in welcoming Emily, and also in thanking the National Audubon Society for their support. Thank you.
I'm very excited to be here. I love talking about water. I'll talk about it all day, every day. So I appreciate you guys' patience, a little bit of technical difficulty we had earlier. But I'm pretty excited to talk to you today because, as Professor Clyde said, I work primarily in water. And as we know, water has been of a hot topic here in the last couple of years. Here, you get the whole presentation in backwards. And I think that one of the questions that comes up the most regularly is, what are we going to do with our broken water laws? And this question just gets to me because I don't think it's the right question. And I think it distracts from kind of getting to some of the really complicated and really critical pressing issues we have here in the state of Utah, but also in the West more generally. And so when the Stegner Center asked if I wanted to do this talk, I was like, yes, I'm happy to get up there and defend the Prior Appropriation Doctrine. And now I want to tell you why, because it's actually a lot more flexible and a lot more workable than I think it gets credit for. So it's me, Emily Lewis, Professor Clyde indicated all these things. I do have a weekly water podcast, though. So if you are interested in water matters, I interview people who do work in water in all kinds of ways. And it's a great way to kind of just like keep in touch with what's happening. I use it as a tool just to learn about things. So it's super fun. I really enjoy it. I'm also from Wyoming, so we always have to have the buffalo. Okay, so first things first, I want to talk to you a little bit about the perspective of which I've created this presentation, because I think that that's really helpful to understand kind of the conversation. And this is really going to be a little bit of a nitty-gritty water law, water rights presentation. I always start every water law presentation I do, or conference, or class with this image. Does anyone here in the audience know what this image is? Okay, a couple people. So this is, people in my class know what it is. That's right. So this was John Wesley's PAL vision for the West. He was an incredible human who did much more than just run the Grand Canyon with one arm. He basically created five offices of the Smithsonian. He created the Public Land Survey System, an incredible thinker and visionary. And this is kind of one of his most visionary elements. This is how he would have divided the West. He would have done it by watersheds. Instead of these big square blocks of land out of federal territory, he would have divided the Western states based on its water resources and honestly really avoided a lot of the issues we're finding right now. I sit in a lot of meetings. I go to a lot of interesting conversations. And the main theme that comes back to me in most of these meetings is I walk home and I go, oh my God, how do we unwind the West? Like all of these questions that we're asking about water come back to kind of fundamentals. And if we'd only taken John Wesley Powell's advice, we'd be in a very different place today, but we're not. So I want to talk to you a little bit about the context of how I'm approaching this conversation today. So we need flexible and resilient solutions for water yesterday. You know, we are at an acute moment in time. We're getting much less water than we thought we were. We have increasing demands. And so we really need a lot of tools that are going to help us address kind of these changing conditions. And so I come from the approach that I'm much more pragmatic. I feel like collaboration is much better than conflict. I think that, you know, we really need to find what's actually going to work and actually get that going. And so we have a lot of considerations about what is probably going to be the most effective legal doctrine. You know, there's a lot of interesting doctrines out there. Australia threw out their water law and tried again. It's kind of working. You know, there's rights of nature's doctrines. For me, the biggest issue for us is that we don't really have time to explore a lot of those, you know, kind of more esoteric or potential other alternatives because we have climate change, because we have such huge demands on our water right now. We kind of need to focus on what's going to get us to the solution the quickest. And I personally feel like that is the Prior Appropriation Doctrine. Got a bunch of things. Great Salt Lake. We don't need to say anything. Super interesting graphic about where the population centers of Utah are going to be. Those big staggering elements. Water law is, you know, kind of like a tanker. It's going to move really slowly. I hope it's not the evergreen tanker. Hopefully we can get out of our own way. But I think that, you know, understanding that there's a lot of institutional momentum for using this doctrine is really important. And then I want to say real quickly, Western water law is not perfect. It excluded huge groups of people. It excluded interests. You know, it was built at a time that had a very limited or myopic view. That doesn't mean that it's all bad. And I'm not going to talk too much about some of these caveats, but I want to mention them. And the other thing I want to mention is that anything having to do with water is complicated. It's a big sweater. You pull one little string and everything else will fall apart on the other side of the sweater. And so that's kind of the context of why I think it's so important to understand and kind of work within where we are now. So for me, the Prior Appropriation Doctrine, which we're going to talk a little bit about today, I like it because it's actually very stable and very flexible. And those are the building blocks you need to kind of build on and move into more innovative or interesting water policy. Some of the things that it does is it prospectively determines how to allocate water in times of shortage. So we're not going to be fighting about it when shortage comes. We already know what we're supposed to do. It's a hyper-defined property right, so that people are on notice of what everyone's interests are. You know, it's clear, it's not confusing. We can define and assign values based on the doctrine, and allows us to contract and kind of come up with alternative ways to use our water that use the water rights as the building brick, but like allow us to kind of build some new and creative things. And I think most importantly, is that the Prior Appropriation Doctrine is built on a conditional right of use that's able to basically develop and evolve with society. And I think that's an element that doesn't get talked about quite enough because I think it's something that happens kind of inadvertently and over time. And so when you actually kind of look back at some of the changes we made, you can actually see how flexible the doctrine is. So I don't know who this guy is. I found him on the internet, but I really want him to be my friend. I love to two-step. I love going dancing. And I like this guy. And so this is my theme for the day. We're going to dance with the one that brought us, and we're just going to learn some new steps. So, okay. So what are we going to talk about today? It's kind of a hodgepodge a little bit, but I want to spend a lot of time talking about like the physical elements of water rights and kind of like how water law works, because I think that's really important to have a more nuanced discussion about where we go into the future. But I think it's also really important to talk about, like, what are we talking about? Like, what are the basics of what we're talking about? And what are the foundations of kind of how we got here? So what are we even talking about? So water is a very unique element to work in. It's different than other natural resources. If you have mining, the mine is there. You're going to go get the copper where the copper is. If you're a forester, you're going to get the trees where the forest is. If we run out of trees to burn, we can burn propane. There's alternatives to it. There is no alternative to water. It's unique, it's useful, and it's essential. And it has elements on it that make it very kind of difficult to regulate and need to regulate in a way that's different than other natural resources. It has infinite uses. We need it for everything: human health, industry, domestic uses. It's essential, sincerely essential. It's movable. You can move it long distances. It's not tied to the specific place of where it originates. It's finite-ish. It is in the water cycle, but once we don't have enough, we don't have enough. Like we're learning here in Utah. It's degradable, so we have to be very careful how we use it. And it's pretty much the engine of all activity. So essentially, water is important and people are going to fight about it, who has it and how they use it. That's pretty much the sum of what we're talking about. So at like a very base, what we're talking about, a water right defines a legal claim to something valuable. A water right is defining how and who can use rights to water. So why does it matter if you have a right to water? Because water rights are in the nature of real property rights. That gives the owner certain privileges. You have the right to possess it. You have the right to control it. You have the right of use and quiet enjoyment. You have the right to lease and license it. You've got the right to privacy and exclusion. You've got the right to dispose of it, to transfer, inherit, gift it, and you can use it as collateral. I have a little bit of an asterisk in here because we're going to talk specifically about how water rights are different than other real property rights. But basically, it gives you control. If you own the water rights, you have control of an incredibly valuable asset. Mr. Burns. So how did, the common law to water rights really evolve? So there's really two tracks. We're going to talk primarily about the Prior Appropriation Doctrine, but I want to reference that it's not the only way to regulate water. So in common law, there are kind of two tracks of water law developed. We had riparian water rights. They're kind of based on ownership of land. You get water as an innate element of your ownership of the property, and you have appropriative rights. And appropriative rights are kind of more of we're going to reward those who went out and actually used the water. They went out and got it, and we're going to reward rights on that basis. So the ownership by riparian rights comes from a very old, Old English, Old Roman concept of ad coelum, which is basically you own everything from the earth to the sky. So it's a discrete ownership concept of where everything that you own, any parcel of land you own all of the rights and assets extending above the land and below the land. So this included a legal right to water. This is kind of the basis for like the riparian rights doctrine. In contrast, the appropriation concept is based on basically like going out and getting the water. And it's got a couple different elements to it. There's a Roman law aspect to it where there are certain things that can't be owned. So you have to kind of, there's negative ownership that you have to actually go out and kind of express dominion over it. There's the appropriation element of it where rights of private ownership are gained through actually going out and grabbing it. And then there's the right of capture, which is kind of similar to oil and gas and other kinds of law where if I make it mine, it's mine. And this is kind of how, here in the West, we've taken to this appropriation concept. And we'll talk a little bit more about why and how. But imbibed in both of these concepts, though, is this really important element of public ownership. So water is so essential that there needed to be a way to say, yes, we've developed these tracks for who can assert water, who can assert a claim and a right to water. But at the end of the day, this is such an essential element. We can't really let private ownership, deprive the public from the benefits of this resource. It's that essential in life. And so we needed a way to kind of imbibe in it this public element. And so what came and developed over time was basically like this public juris, publici juris. I'm not very good at Latin, which is basically saying, yes, you have a right to this water, but you don't actually own the water. Your right is distinct and different. It's not like you own the wet water molecule. Instead, what you're owning it as, you own the right to use of that water. And so in the riparian rights system, basically this kind of moved to, you have to use your right reasonably with everybody else so that you can't take it at the exclusion of others. In the Prior Appropriation Doctrine, it created these kind of conditional property rights of use that you get to use the wet water molecule subject to how society thinks we should do it. This is my favorite word, usufructuary rights. So water rights are usufructuary rights. It's a conditional right of use. It's like real property, but a little bit different. You don't own the thing. You don't own the wet water molecule when you own a water right. You own the right to use that wet water molecule subject to the conditions that society sets. So that's kind of like the background of how, the concept of like having a legal right evolved, how it evolved in terms of, this concept of having a natural resource like water, and, that has kind of this inherent tension with this public element of the right of use. In terms of here in the state of Utah and across the West, what's really important more is kind of the concept of how the Prior Appropriation Doctrine developed here in the West, because it really does inform what we do with our water today and kind of what constraints we have, but also kind of what opportunities we have. So prior appropriation. One thing I love about water, I had a Civ Pro teacher here who's no longer here named Professor Wildermuth, who on like our first couple of days of Civ Pro, she goes, "Oh, Civ Pro is so easy. It's just a bunch of rules. It's not like that black box water law." And I was like, oh, that's what I want to do. And then I hated Civ Pro. So I'm happy to be in black box water law. That being said, water law is actually a lot more literal than people understand it to be. It's actually pretty straightforward. Prior appropriation, existing or coming before in order of importance. The first person there, appropriation, I've taken it. We are basically rewarding those individuals who took risk and made Western development happen. That's how our Prior Appropriation Doctrine is sincerely based in. In terms of the specifics of how our Prior Appropriation Doctrine developed, it's really important to go back and put this in context of the history. One of the things I think is really interesting about water, and we look at kind of, the stories about it and, all the lore, we kind of focus on the American West as the genesis of Western water law, and it is. But the American West didn't happen in a silo. It was this huge convergence of a ton of activities happening in the mid 1800s. And so, for example, that top map right there, the one with the kind of beige one is, for example, a map of the railroads and all the land grant lands that came to railroads. I mean, this was a huge amount of expansion into the Western territory. So we have all these people coming out. We've got gold strikes. We've got the homesteading acts. We've got Mormon settlement, other pioneer settlement. We've got railroads. We've got the end of the Civil War, cowboys becoming soldiers. And we're realizing that as we move west, this riparian rights doctrine that basically, gave water rights based on land ownership really didn't fit what was happening in the West. The map on the bottom that you can kind of see for you guys, it shows you all the rivers on the east. There's lots of little rivers. There's a lot of water. The second you hit that 100th meridian, not so much water. We needed a new way to figure out how we were going to divide out these limited water resources amongst the new populace. I just love this picture because I think it's a good example. The first one in the corner is a mine. There's the railroad in the middle. We've got downtown Salt Lake at first parts of settlement. In the corner in the bottom, we've got, a big irrigation pump. And you probably can't read it, but it says clean water, it says cheap water for irrigation. They're putting it out there right away. The guy in the middle is a soldier from the Civil War. It's also important to remember that the Civil War was ending. All these people were displaced. It was a very difficult place to be in the East. So there was a lot of interest in moving west and kind of starting anew. And then the other element I added just this morning actually is just a picture from Ellis Island. A lot of the Western development is also spurred by immigrants coming for a new land. So this is really a hodgepodge. I also just felt like Kevin Costner's career pretty much just encapsulated the West. It's also not ironic. I understand that this is also a not ironic picture of a white male privileged landed man perspective, but there it is. One person, he does it all. In particular, though, of all those elements, there were kind of two activities that really did inform and frame how water law developed. One was the mining camps. So, we had all these people coming out. If you've ever read 2 Years Before the Mast, when they go to San Francisco before the gold strike comes, it's super interesting. And then they talk about how San Francisco blows up overnight into a city of 100,000 people. And so, we had all these people coming out into the federal territories, trying to strike it rich. And we needed a way to divide out these limited little streams between people. And so the mining camps kind of developed this concept of first in time, first in right. The first person who got there got to use the water at the expense of the later comers. So if you want to come out here and make your fortune here in the Western United States, get out here first. So the kind of mining camps kind of started developing this kind of first in right, first in time concept, which is going to be, basically a central component of the prior appropriation system. And then we also had the pioneers. So the pioneers came out here. And so they came out in wagon trains, they came out in individuals, they came out in a bunch of different forms, but they also had some common concepts. This concept of, more communal use of water. We're here together. We have to make this barren land green. We have to work together to literally survive. And so kind of this concept of beneficial use comes up, where it's, if you're not going to use this water to help us survive, we're going to give it to somebody else who will. So if you don't use water, this concept of use it or lose it starts to kind of come up as a way to keep tabs on the water resources in these developments and ensure that we're continuing to move forward in progress. So really kind of those two strong elements kind of start to frame these concepts of the prior appropriation doctrines. I think it'd be really remiss to just not to mention, there's actually a federal incentive to get people out to these new lands. So, it's not just the random people who are, the first adopters. The federal land patent system, the disposition of federal lands to private interests to promote the settlement of newly acquired territories, or basically manifest destiny. This cannot be understated, because all the water rights, the early water rights in the West were meant and acquired and appropriated to fulfill this vision. We were going to make homesteads. We were going to make cities. We were going to actually settle this open, barren land. Just a couple great little graphics here. The one in the middle kind of talks about Louisiana Purchase. We've got Treaty Guadalupe, kind of how and where the United States acquired its lands. I think this is also kind of interesting too. This is a contemporary picture of the Western United States. So all in the bottom corner, all those colors are still in federal ownership. So, we disposed of a lot of federal land in the territories to private individuals, but we also held a lot of it. And so all those folks are kind of coming out and, making their way. And so, just a quick, history of a couple of the homesteading acts on the federal territories that really promoted this. Started 1848, 1850 Donation Land Grant Act, 1850s, there's kind of small pockets of people around. 1860, we had the original Homesteading Act, but it was actually passed by Congress, but vetoed by President Buchanan because it was too egalitarian. It would let anybody go out into the federal domain. And President Buchanan, remember, this is 1860s, right before the Civil War, thought that it needed to be a certain set of folks who had the ability to go out and settle the West. 1862 rolls around, we try again, we pass the Homesteading Act of 1862, which really lets anybody come out to the West, immigrants, women, whomever, and really opened up the West to Western settlement and kind of really the initiation of appropriating a lot of water rights in the West. Kind of two other important statutes, and we don't need to go through this talk, is the 1866 Mining Act and then the Desert Lands Act of 1877. Both of those are kind of seminal water right laws that kind of acknowledge the fact that people have been out in the West and their rights to use are going to be recognized and acknowledged. So kind of basically from this kind of development of the West, we have kind of a couple key principles that develop through the water rights common law doctrine. We've got beneficial use, kind of the basis, measure, and limit of a water right. Those pioneers are really trying to put that water to use. We've got the prior appropriation doctrine. We're trying to figure out how we're going to, allocate water between various individuals. We're going to do that based on who got here first. And then also kind of based on these two concepts, kind of two other elements or concepts to also begin to develop. One is a non-impairment concept, where because we're going to, recognize that these senior water right holders get the benefit of their investment by having a very valuable water right, we're not going to allow anybody to impair that water right. So we kind of have this impairment concept come in. And the other side of beneficial use is forfeiture. If you don't lose it, we're going to take it back and we're going to give it to the public. So I have this kind of like upward spiral element, because these concepts are going to show up here in a few minutes about how we actually design and operate water rights. So these are kind of the key operating principles. And then these key operating principles kind of get broken down and structured into actual kind of like water law and water rights. So I think it's important to spend time talking about what actually a water right is and kind of what it is, because I think we have a lot of, big abstract conversations about water and big abstract conversations about water rights and water law. But like, really it comes down to the nitty gritty. Like it really comes down to individual water rights, what they are and what they represent. So here in the state of Utah, what is water law? It's a legal system to provide order and certainty in the beneficial use of Utah's water. And I pretty much just stole that from the state engineer's website. So that is their mission. The thing I love about water law is that water rights are like literal, like they're very literal. They're not this black box that people think they are. They're incredibly specific and they're incredibly practical. The elements of a water right literally describe how the water user is to put water to beneficial use. It's physical descriptions based on practice and geography. And so this, on the side of here, this is an actual water right. I came in and I did a guest lecture a long time ago now, maybe like 7 or 8 years ago, for our former Dean Adler. And I'm not throwing the Dean Adler under the bus, but I am. And I put a picture of a water right database page up on the screen. And I said, who knows what this is? And nobody knew what it was. And I was like, okay, we need to actually get into administration of our water rights. So this is the pictorial version of a water right on the state engineer's database. There's a map of one, and that's a picture of a head gate, kind of showing you that things come back to the actual physicality of the use. So water rights are these hyper-defined property rights informed and defining beneficial use. Like, how are we going to cut up the rivers that we have? How are we going to cut up the lakes that we have and actually ensure that individuals are putting them to use like we want them to? We're going to make them hyper-defined. We're going to cut out little squares of water, tell you what you can and can't do with them, and that's your actual water right. So kind of some of the key elements of a water right are the nature of use, or the purpose of use. It's the priority date. We've already kind of hit on that concept with who, first in time, first in right. It's the quantity, and we're going to talk about quantity. There's an element of quantity that doesn't get enough conversation that I think we need to have more public discourse on, which is duty and consumption. We're going to talk about that in a second. It's kind of like the shadow element of quantity. The source of use, the place of use, the point of diversion. There's a couple other kind of minor elements, but those are the big key ones. When you have a water right, those elements are going to be defined. And the important thing is you can only use your water right as approved. So you can't use your water right in any other way besides how it's defined. If you want to do that, you need to go through a whole administrative process, which will have an impairment analysis, which will kind of, make sure that your change is not going to impair others. And so when we have kind of general public discourse about water, you have to understand, you have to start where the water right is. And if you want to go to a different use, that's feasible, but it is a process. And I think we're kind of learning that now as we have conversations about like the Great Salt Lake and the Colorado River. It's not just, not every water right is not a water right is not a water right. They're all individual, they're all different, and getting them to your intended use is going to be a process. Okay. So back to kind of the nature of use. So under Utah law, beneficial use is the basis of a water right. So basically, you get a water right to use and only use water for the authorized nature of use. So traditional beneficial uses are irrigation, domestic, stock, power, municipal, industrial. These are the beneficial uses that really did promote Western settlement. If we're going to make the desert bloom, these are the things that you would give a water right for. However, because these are usufructuary rights and society can set the conditions for how we use them, we are starting to see development of contemporary beneficial uses. Snowmaking. I'm sure the pioneers did not anticipate snowmaking. Waterfowl habitat. That's one we've been talking a lot about lately. Recreation. Here in the state of Utah, we don't have it, but in Colorado, you can get a water right for, kayak park or whitewater recreation park. In-stream flows. We've had a bunch of activity here in the state of Utah on in-stream flows. But basically, like these are beneficial uses that are evolving to meet the contemporary needs. So the other element of a water right that people need to understand when they're kind of talking about water is the priority date. So we've kind of discussed that this came out of the mining camps and at the beginning of the mining camps, but this really is the first in time, first in right colloquial conversation piece that you hear about. So the priority date of a water right is the first date that water is put to use. It determines the order water users on shared systems take their water. So the oldest or most senior water user in the system takes all of their water before the next person in line takes a drop of theirs. So a junior water user too, depending on where you are on the system, could potentially watch an entire stream of water flow by them, and they would not have the legal right to take it because a senior water user is downstream. So it's kind of interesting. Water rights, you have to think in multiple dimensions. You've kind of got both like the physicality of the actual water right, but then you've got temporal elements about when water is happening. You've got geographic elements about where the water is. It gets very complicated very, very quickly. But one of the things that is very helpful, and one of the reasons that I think the Prior Appropriation Doctrine is useful for today's circumstances, is that having this priority date does two things. It establishes the value of a water right, because the older the water right is, the more likely is that water right is actually going to produce wet water. I have a couple, I have a private practice and I've had people come in and say, hey, I've got this water right for sale. Will you look at it? And I'll like open it up and look at it. And I'll be like, this is like a 2015 water right. I would not spend any money on this. Do not buy this. And then meanwhile, my grandma a couple of years ago said, I got some paperwork from the state. And I was like, okay. And she's from Grantsville originally. And I was looking at it and I said, Grandma, you have an 1851 water right. And she's like, oh, is that good? And I was like, yeah, that's really good. What happened to it? I gave it to Uncle Mac. Oh, great. Okay. But so that's the saying that this priority, it's really, really important because it establishes the value of those water rights. And when we start moving into like water leasing, water marketing, any kind of movement of water for contemporary needs, these priority dates are incredibly important. The second thing that this does is the priority date creates stability. It's pretty draconian. Yeah, you get all yours before the next person does, but we know what's going to happen. There's no question about it. We can contract around that. We can make different agreements around that. We can subordinate the priority dates if we want to, but at the base nature, we know what's going to happen in times of conflict. And that's incredibly important and an incredibly stabilizing element that I think really does not get enough play here in our conversation. So another element of water rights, when you guys are thinking about these conversations that we're having in the public right now, is the quantity. So beneficial use is also the limit of a water right. So you only get to divert the amount of water needed to fulfill your use. If I've, grown some alfalfa in Price, actually Price is a terrible example because they have a really high value. If I'm growing crops in Summit County, and we have a 3-month short growing season, I probably don't need to apply 8 acre-feet of water to an acre of ground. I would just saturate it and make it wet. So the state engineer is going to come out and they're going to say, we're going to determine how much water we think you need for your intended use. And that's the only amount of water you get. And that's intended to basically avoid waste. So we're only using the right amount of water for the purposes that we're having. So for example, a house is 0.45 acre feet. An acre of irrigation is about 4 acre feet, depending on where you are. 1 cow is 0.028 acre feet. It gets very granular, very, very fast. And so just if you don't work in these terms very regularly, an acre foot is 2 acre feet is about the size of an Olympic swimming pool. It's the amount of water to cover 1 acre in 1 foot. And that is the standard bearer metric for which we determine the volume of a water right. We also on quantity though have a second element, which is CFS flow, which is cubic feet per second. So that's about the size of a basketball. Both of these items are limits on a water right. So I like to tell people it's kind of like your bathtub. The size of the tub is the acre foot volume. The CFS flow is the size of your spigot. You can have a huge spigot and fill up your volume very quickly, but that's all you get to fill up. Or you can have a small spigot and fill up your volume very slowly, but at the end of the day, you only get to fill the amount of your tub. So both of those things are limits on a water right. The other element of quantity that I think is incredibly important that we have a greater understanding of in the public is that under Utah law, beneficial use is the basis. You get enough water to fulfill your specific purpose. The limit, you get enough water to fulfill the need, and the measure of your water right. Your actual legal water right is only what you consume, only what you take out of the system. And so you could have a 4 acre foot duty value, which allows you to divert 4 acre feet per acre, and that you would apply that water to some crops. And through evapotranspiration, through the crops eating it, your alfalfa really only consumes about half of that water. The other half of the water goes back into the system and then basically creates return flows for other people. And so when you want to go basically move your water from irrigation needs, for example, to a domestic need, your legal right that you get to move is only the amount you consumed. So if you had a 4 acre foot duty value and it was a 50% depletion rate, then all you really get to move is 2 acre feet. Because if you removed more than that, you'd basically be hurting downstream water users. And that's that non-impairment standard. So in using these water rights, we also have to look at the system as a whole. And this is something that comes up a lot. I'll have people kind of bring me a water right and they say, oh, I've got 400 acre feet. I can make 800 houses. And you're like, no, not really. Actually, you only have X 200 acre feet. And so understanding that the measure of your legal limit is actually what you consume. This is also incredibly important because as we move to more advanced technologies like OpenET, which is satellite technology that can tell evapotranspiration from the air, the eye of the sky, we're going to move to things like actual ET. So instead of having just a set metric that was set in the 80s up in USU, we're going to actually be able to say on this acre of ground, this amount of water was actually consumed by this actual crop. And that's going to allow us to do things like move to less depletive crops and put more water back in the system for potentially leasing. It's going to allow us just to really tighten the screws on how much water we need and how much water is actually being used. The other elements are important, but they're not as important, but they're things to think about when you're having conversations. The source of supply, what creek is it coming from? What river is it coming from? You have to stay in that source of supply. The point of diversion, where are you physically taking that water from the source? Is it a head gate? Is it a well? You have to take it at that exact location. You can't move it downstream because you might take someone's water in the intervening period. The place of use, here, that map, this green map right here, is an example of a water right place of use. That's probably a municipal water right because it covers a large area. Water rights are pertinent to their place of use. They can and can't be, but if they can be considered a pertinent under certain conditions. And that's a picture of some wells and different points of diversion. So those are kind of like the elements of the water right. Just to go back real quickly, when people start talking about water, what that means, though, is you have to have a key understanding of each one of these things. If you want to move water, if you want to use it for a different purpose, if we're talking about leasing, if we're talking about big scale water policy, that's great. But it all comes down to the individual bricks of individual water rights and the individual elements of those water rights. So very quickly, it becomes quite complicated to make sure that we have the right water rights, try and do the right thing for the right places. Which kind of gets us to, I did want to cover a couple of key elements regarding applications of water rights. We've kind of talked about how they developed. We've kind of talked a little bit about, what the elements of a water right are. That water law doesn't stop there. Water law here, especially in today's day and age, really comes down to how water rights are applied and administered in the real world, not just on paper, but like what's actually happening, especially because we are looking here in the state of Utah to, in the very near future, move a lot of water from one source to another, whether that be leasing, whether that be municipal. And so the actual administration of water is something that the public should also have and gain an understanding of, because it's also going to inform how long it's actually going to take us to do some of these things, who we need to hire to do these kind of things. It's a very complicated, you can, just having a stack of paper water rights doesn't really mean you're going to get where you want to go. So again, I just wanted to reiterate, water rights are usufructory rights, right? You just own the right of use. So that also informs not only how water rights are designed and defined, but how we use them in the real world. So because we practice the prior appropriation doctrine here in the West, we're really rewarding those people who've gone out and taken some action to appropriate and use water. That being said, you don't automatically just get a water right. It's a process, because we want to make sure that those people who are going out and saying they're going to put water to use are actually going to put water to use. So here in the state of Utah, we have a statutory application to appropriate system. So if you want to go out and get a water right here in the state of Utah, you would have to apply to the state engineer to do so. That being said, most parts of the state are closed to new appropriations, and we'd be doing a change application, changing water rights from one use to another. But this process applies to both of those processes, both an application to appropriate and a change application. But just knowing here, this is a multi-step process. If you want to change your application from, let's say, irrigation to domestic, you have to file a change application. It has to be noticed publicly. There has to be a protest and a hearing on it. There's going to be an approval and a rejection. There's 2 bites at the apple if you don't like what the state engineer said on your approval. You got an administrative bite at the apple and a judicial bite at the apple if you don't like them. And then once you get a final approval, you still have to go do what you said you were going to do. So there's a period of time where people are actually doing due diligence and perfection of their water rights. And then once they've actually done the thing they said they were going to do, like build 100 houses, the state engineer requires that you prove that you did what you said you were going to do. And you actually have to file a proof of appropriation. And then at the end of the day, you finally get a certificate of appropriation. This process is crazy. It's crazy because water rights can get stuck in any one of these stages. So another element about Utah water, as we're trying to kind of like figure out where we go in the future, is that I've seen water rights stay in this due diligence or perfection stage for 50 years. 50 years. If they are held by electrical cooperative, those water rights, you don't have to put them to use for 50 years, but they're still valid applications. So another thing you need to look at when we're assessing these water rights is, where in this process are they? Are they even perfected water rights? Are they at one of these stages? And this is really important because change applications are going to be the bread and butter of water law. They already are, but we're going to see a lot more change applications for a lot of more complicated matters. And so this is how we facilitate new uses of water. For example, data centers. We in the state of Utah, for some reason, think it's a good idea to have data centers in our very dry state, unless they're the NOVA data centers, which are waterless. And that's not a promotion, but I just think it's really cool. But like, the people are going to go through these change application processes to move water from one area to another. And what we're going to do is we're going to look at each one of those elements that we described earlier. We're going to see how the new proposed elements fit. And we're going to look and see whether or not the water rights actually been used. And then, hopefully, the application can be approved for the new use. But here is basically an example of a change application. Nobody talks about change applications, but this is exactly where all the work is. This is where all the work is in water. This is where all the work is going to be for all the innovative things we want to do. For example, I operate as the Utah Water Banking Program Manager, where we're experimenting with water banking here in the state of Utah. We thought we were doing such a great job. We got our water bank application in, we got all the parties together to sign a leasing contract, and then we filed our change application, and it took a year. It took 1 year to get our change application filed. So in other words, those people couldn't take advantage of that leasing agreement that they already created the year before because we were waiting on our change application approvals. And that's because we were asking the state engineer to do something they don't typically do, which is shepherd in-stream flows. And so as we look to Great Salt Lake leasing, as we look to the Colorado River, this change application process is a critical component of understanding how quickly we can move on those policy priorities, but also what it involves. And so those are also these are just the requirements of what you have to do to get a change application approved. The most one important there is that it will not impair existing water rights. You have to say, by me moving my water from the existing use, the heretofore use, the hereafter use, I'm not going to impair anybody downstream. And that, for something like a complicated change application, might require pretty extensive engineering studies, pretty extensive studies to show that you can actually move to a less depletive use. So we're going to be seeing a lot of more complicated and interesting change applications. I've only got a couple more slides, and I'm going to hopefully get a chance to answer some questions. The other thing that's really important to understand about water and water law here in the state of Utah is once you've got all your paperwork figured out, which is pretty much what we just talked about, you still have to move that wet water molecule from point A to point B. That is really hard. So here is an example of, it's all going to come down to distribution. It's all going to come down to having enough instrumentation in the system and enough knowledge of the systems to understand that we can say, okay, this water right has an 1855 priority date. It's super early. Right now, it's in Cache Valley. We want to lease it to the Great Salt Lake. Between Cache Valley and Great Salt Lake is 76 miles, 75 miles of river. In between there's going to be someone who's got an 1870 water right, somebody who's got an 1890 water right, somebody who's got a 2012 water right. And even though that water right we're leasing to the Great Salt Lake potentially has a really high priority, we're going to have to tell every single one of those people they can't take that water, and they're going to have to watch it go by. If we don't have people on the ground, instrumentation, telemetry systems that give us real-time monitoring data, that task is incredibly hard. And so this is really where I think most of the activity, resources, and time here in the state of Utah needs to be spent in the next couple of years. We really need to get modernized distribution systems so we can actually move water from point A to point B and actually know it's getting there. Otherwise, nobody's going to participate in marketing activities. Nobody's going to want to invest in conservation activities because they're not going to know they're going to get, any kind of market opportunity off that. So I put little hearts on all these people, and Candace, she should have gotten a heart. These are our state engineer staff. Teresa Wilkinson is our state engineer. We got Jared Manning, and we've got all of them, I'll tell you. But basically, I put hearts on these guys because they're wonderful. I ask them lots of hard questions all the time, and they actually don't like me. They do, but I ask them a lot of hard questions all the time. They're always like, great, we're really happy you have this project. But these guys do really hard work on really limited budgets, and we need to give them all the money that we can and have them pay their staff comparable salaries so they don't get picked off by private industry. And I mean that as actually a state policy priority. If we don't have good staff, educated, well-informed, and they are, staff that stay with the state engineer's office, we are not going to be able to do any of the water policies that we want. Here's just another example of moving water from point A to point B. Here's a little point. Here's East Canyon Creek up here in Snyderville Basin. As part of the water banking project, we installed 6 telemetry sites on a 2.5 mile stretch of creek. We needed 6 sites to know whether or not we could move water to get to an in-stream flow capable of supporting fish on a 2.5 mile stream. So if we're talking about moving water really long distances or for really important purposes, this is going to be a lot of instrumentation. It's going to be a lot of investment to get to a place where we can really have those conversations with any certainty. So I guess where to, what's next, and why it matters. I'm going to repeat this slide again. I actually think the Prior Appropriation Doctrine is a really good doctrine to be with because it really is stable and it's really flexible. We know what we've got. We know how water is going to be distributed in times of discord and times of shortage, but yet it's still flexible enough to move and evolve with the needs of the day. And so in my mind, I think that there already has been a lot of really exciting ways to work inside the Prior Appropriation Doctrine that I think we need to kind of emulate and move forward. I just wanted to give you one really good example of this. So this is the Bear Lake Settlement Agreement. The Bear Lake Settlement Agreement was entered in 2004, so actually quite a while ago now, almost 20 years ago. The senior irrigators in Bear Lake had a very senior priority water right. So if they wanted to, they could have called on and used every single, pulled basically Bear Lake dry if they wanted to. That didn't sit well with the environmental interests because Bear Lake is also a natural asset for the state. And also there's some power generation that's included on some of the flows in the Bear River from Bear Lake. So instead of fighting, instead of saying, I'm just going to use my senior water right, instead, those parties knew what they had. They knew what their value was. They could come to the table informed, and they said, okay, we all live here though. And so because we know what we have, and we don't have to fight about that, we can come to a collaborative agreement that basically allows us to manage our water rights in a way that makes room for everybody. So instead of having to redo everything, like some people have advocated for getting rid of the prior appropriation system, you just need to work within it. And by having the stability of those key functions and elements allows us to get directly to the actual conversation because we're not fighting about what we actually have. And that's why I think the prior appropriation system is going to be, is a really good system kind of for meeting the moment, because it can both get us, it gets us more quickly to these kind of conversations, which is where we need to go. I guess here's another example that, we have the prior appropriation here system in Utah, but it's already working, or it's already, here's a good example of, both water policy and programs that, we've been able to kind of use, for example, in-stream flows, HB 33, we adapted our prior appropriation system to allow for in-stream flows here in 2022. That's a perfect example of us using and working within the prior appropriation system. However, we still have a lot of questions, and we would have those questions regardless what doctrine we used. But I think at least we have a good handle on our legal system, so we can kind of start asking more of these complicated questions. That's kind of what I have. I'd like to open it up for, we'll open it up for questions if we have time. Do we have time, Professor Carter? 1 minute?
Yeah, I think we can go till 1:30.
Okay.
If people have to leave, they can slip out. And likewise, our virtual audience can stay tuned in, or if they have to leave, they can take off. But you've presented a lot of information, so the question bank is open, so to speak.
Okay.
Waiting to get questions. Let's see, we should have some. There we go.
I can hear you. Oh.
Go ahead loudly, and
Okay,
maybe I
I'll
can
try to
repeat
do
it.
really loud. So this is interesting. You mentioned the word priorities, and we heard a presentation made, I think it was last year, by a professor of law from Texas about who's going to set the priorities. You maybe heard her presentation that she gave here. And she essentially advocated changing state law because you had no system to where if you decided it was more important to allocate more water overall to growth and build houses and people and domestic use versus growing alfalfa, there's no mechanism other than what you pointed out, that you have to sit down around a table and everybody has to agree to it. Is there a way to do that that is allowed in the law right now so that either it can be forced to make the change based on what the public wants, or do you have to change the law to get there?
Well, I think there's two elements of that. Kind of depends on what we want to do as a society. And this is the rub of water rights in general. We've got water rights are private property interest. People have made investment-backed expectations on those. You go talk to any agricultural producer and they will tell you exactly how much their combines cost. And they're intending to have that water for that purpose. And so one answer to that question is, yeah, the prior appropriation is a great way to do this. You know what you have. You know what the most valuable water rights are. You know which ones yield water. Go buy them. Like, let the market be what the market is. And so I think that's one solution. If we as a society determine that we want to reallocate water to new uses, absent an element like a public trust doctrine lawsuit, which I don't advocate for because I think that would spend everybody's time and resources fighting instead of working together, you're going to have to work within some kind of contractual right of use or market use of those water rights, because there's really no water out there that isn't already allocated. And so we're going to have to, basically the conversation is going to be moving those water rights from the existing use to the new use. And I personally am an advocate of market activities for that.
assuming the Jordan River is clean, and I go over to the Jordan River and stick my canteen in there, am I doing something illegal if I take that water and then drink it?
Yeah. Yeah, I mean,
Emily, why don't you repeat the question?
yeah. So the question was, if I go down to the Jordan River, assuming it's clean, and I think that it's made great strides in that effort, and I put my little cup in and drink water, am I drinking somebody else's water right? Yeah, you're probably drinking Salt Lake City's water right. You're probably drinking Salt Lake City's effluent, of which they have a water right, a claim to. So.
And I guess the second part is, when I turn my tap on in Salt Lake City, do I have a right to that water, or who's giving me that water?
So that water, that's actually a much more complicated question than you think it is. But that water is, delivered by Salt Lake City. So you're going to have a payment of service to Salt Lake City for the service to get it to you. The actual water rights associated with the wet water molecule you're drinking could be owned by a number of entities. So it could be owned by Central Utah Water Conservancy District, well, actually the Bureau of Reclamation, but distributed by Central Utah Water Conservancy District or Jordan Valley, because we here in the state of Utah have such a system where we have a really large plumbed system amongst our large municipal suppliers. And so we actually wheel water around quite a lot. And so you might get water that's based on a Salt Lake City water right, based on a Bureau of Reclamation water right, based on a different kind of water right. So that's actually a more complicated question than it appears to be. Warren Peterson.
Hello, Emily. And to Bill's question, I'm the one who will speak on behalf of alfalfa. So alfalfa is a great, or farm ag water has served a purpose in Utah, wouldn't you say, of holding a water right there for higher value uses to come along. But keep in mind, when you buy a water right, you're not just buying the water for its value, but you're also buying out the economic activity that's based on the water. Is that a fair statement?
Yeah, I would agree with that completely. And I think that, so Warren said that, he wanted to make a firm stance for alfalfa because there's been a lot of discussion about alfalfa here in the state of Utah recently. And so agriculture does have about 70-ish% of the water here in the state of Utah. Diverted water. And a lot of our water is in ag. And so there has been a lot of discourse recently about, well, why don't we just take it from ag? What does it look like to, move that water to new uses? And a lot of the water is in alfalfa. And this kind of comes back to that market principle where I'm like, yes, but these are also private property rights. And so if that's something we want to do, it has to be done in a way that those individuals can still maintain, if they want to keep farming, they should keep farming. They don't have to be leasing or selling. They can be doing what they've been doing. But those who are interested in doing something different, when those agricultural water rights come out of production and put to new uses, they do have a very large ripple effect on the local economy. It's the seed grower, the truck driver, local kids. We do have a pretty robust agricultural economy here in the state of Utah. Yeah.
Elaborate a little further for his comments and also the men. Is it comparable, you said something about a public trust, is it comparable to like eminent domain law for?
So there's actually explicit eminent domain for water rights if you wanted to do that. But the public trust doctrine, and I didn't include it here, the public trust doctrine kind of hits on that concept of the fact that water rights are usufructory rights. So not only does society or the state of Utah get to set why and how those water rights are used, but the state also holds those water rights in trust for the citizens of the state of Utah and has to maintain them for certain values. And so there's a question of, if the uses that we have here in the state of Utah are potentially threatening those values, is there an ability to kind of get into like the inherent nature of a water right to claw back water for other purposes? It's been discussed for the Great Salt Lake as a potential solution. Here's my retort on that. I think that's a fascinating legal topic, and I think it's really interesting, and I think there are some inherent issues and questions in there. But again, in talking about the context, I'm very pragmatic. And so using that kind of a tool to get water to new uses, I do not think is going to be the most effective way to do it because they're really hard questions. So the one case that we talk a lot about for the public trust doctrine case is the Mono Lake case, where basically they dried up Mono Lake and then they shut off the irrigators to fill the lake back up. That was one water right owner. That's how they were able to do that. If that was something wanted to happen here in the state of Utah for example, like the Great Salt Lake, we'd have to talk to tens of thousands of individual water right users. Would we do that based on priority? So if we did it where we cut off the most junior ones first, our municipal water system is based on junior water rights. All of the water rights in Jordanelle and the big dams are 1950s water rights. So then when we just cut off our municipal water rights based on priority to fulfill a different use, would we do it proportionally? Everybody take a 10% cut? How would you manage that? And so even though that these legal tools exist, I just think there's a more practical and pragmatic way of getting to the solutions that work inside the existing doctrine without having to open very hairy cans of worms.
Emily, we've got a few questions on Slido. I'm going to try to consolidate to given the time, but several of them speak to equitable issues, particularly related to our indigenous population. And probably what captures this is, can the prior appropriation system include or consider indigenous water rights and land rights?
I have to tell you, the prior appropriation doctrine is fantastic if you have a quantified tribal right. So typically, you know, yes, I mean, this is one of the caveats to talk about at the very beginning. You know, based on the priorities of Western settlement in the mid-1800s, you know, tribal members were not given water rights typically. You know, environmental purposes were not given water rights. Very specific reasons for giving water rights, and they didn't extend to those groups. But now we do have a means under prior appropriation doctrine to recognize tribal water rights and quantify them. They're state-based water rights, so they just sit into the system like everybody else. But typically those water rights have a priority date of the date of the reservation. So typically they're very early priority dates. And they also don't have some of the features like forfeiture concerns or use concerns, so that once they're quantified, the tribes aren't at risk of losing those water rights for non-use. And so I think that the system has a long way to go, but we are, it can accommodate tribal rights. And I think there's been a lot of really good activity on this. The Water and Tribes Initiative with Professor Tanana here has done great work on tribal water rights recently. And so it can fit inside the system, but it definitely needs attention.
As a practical matter, to what extent have those water rights been clarified here in the state?
I think we've got everybody but the Mountain Ute tribe, right, Warren? Maybe not Goshutes, but Navajo has a quantified water right. They've just finished the Navajo water rights settlement. They got additional water. They got additional funding in the bipartisan infrastructure bill. So I think most of our tribal water rights are quantified except for Ute Mountain and Hopi, maybe. Yeah, a couple of them. But we're actually further along than other states are.
Okay. Another equity question speaks to that given that this is a private property right, does it result in individuals with wealth using their resources to fulfill their water needs before the water needs of those with fewer resources, their needs are met?
Maybe. I think it would come down to the context. You know, honestly, like we probably already saw like the T-Boone Pickens style folks go out and drill wells and get to, you know, try and monopolize water. One thing we have here under the prior appropriation doctrine that we didn't talk too much about in this talk is it is an anti-speculative doctrine. So you cannot acquire a water right if you're not actually going to use it. So moneyed interests can't come in and just buy up all the water and sit on it. They actually have to use it. I don't know if that really answered it.
That reminds me of, I believe, a news story not long ago of Eastern big money interests seeking to acquire water rights. I think it was in the state of Colorado on the western slope with the intent of moving them to the eastern slope and making money off of it. Yeah.
Potentially.
That fits within the system, I take it.
I mean, it is a market-based system, but it does have checks and balances. You know, I mean, like if we as a society feel like we want to put more conditions on our water use, I mean, that's what we did in 2020 last legislative session. You know, we opened up the ability to use our water for in-stream flows. That was a public priority, you know, and so I think that there's always going to be an equity concern because there is a private property element to it. But I also think that there are ways around that. You know, if the state really thinks it's a priority, go buy the water rights and give them for what they need.
Another question or point, development of these laws seems reactive and not very visionary. Your thoughts on that?
I think the Transcontinental Railroad is pretty visionary. I think at the time when, all these water rights were first appropriated, they were doing some pretty visionary things. I think the question now is, how do we take a system that was built in the 1850s and make it work for the 2020s? I think that is the challenge, but I think we're doing lots of very innovative things. I think that water leasing here in the state of Utah has a lot of really great potential. I think we've invested hundreds of millions of dollars in agricultural efficiency in the last couple of years, and finding a way to work within our water system to recognize those savings so that they can be used elsewhere or leased. I think that I think a lot of innovation is actually occurring.
And there's a question. Can you give us a quick thought, given the laws that you've outlined, as to how, working within that system, we get more water into the Great Salt Lake to address the issues there?
Can I go back? Can you put me back on the screen for a second? I don't know if they can. I'm going to be really frank with you. I think we have the laws we need to get back into the Great Salt Lake. I don't think we have the infrastructure to get water to the Great Salt Lake. I think that we want to talk a lot about fancy policies and fancy, really this is the slide that would be helpful. We want to talk a lot about fancy policy and, paper, but the reality is, if we can't move wet water and track where it's going, nothing we do at the Hill is going to matter. And so for me, I think the last 2 or 3 years, the state of Utah has done a yeoman's work of adapting our water laws to be more responsive to today's conditions. And now we just need to put the money behind getting our infrastructure updated to use those laws. Warren and I are on the same page on that one.
Is the legislature likely to provide the funding to do that?
I've been pleasantly surprised. We lost last year 3 or 4 really strong, stalwart advocates for water in the legislature through retirements and moving positions. And it seems like a lot of folks have stepped up, especially with the Great Salt Lake, with an interest in looking at water. And I think that if asked what we should do, this is what I would tell people. And I think people's eyes are on it, and this will trickle to the top. Warren, do you have a comment on that?
Yes, the legislation put in place last year basically answers the question of how to get it to the lake. And the budget talk this year is that there's going to be some serious money, hundreds of millions of dollars put toward getting water to the Great Salt Lake.
Yeah, and I think that's going to be both in leases and infrastructure.
Just to repeat that answer so that everyone, both online and in the room, hears it, that last term, legislature appropriated several hundred millions of dollars to try to help move water.
This term, yeah. Last year we did the laws.
Last year the law and money, this year more money.
More money. Okay.
Yeah, more money.
Okay. Last year
it's buying
law
things.
and some money, and this year it's expected that more money will be forthcoming to facilitate this.
It seems like there's a palpable urgency on this matter that I think people are taking seriously.
Okay. Any final questions?
Yes.
How did you become a water law expert? I don't imagine somebody growing up says, that's what I want to do with my life.
I actually came to law school wanting to do water law. I was a raft guide, and actually what got me to do it is that we would do multi-day river trips on the main salmon, and you would drink the water and it would be so clear and so clean. And then we would the next week go raft Hell's Canyon, which is below several dams on the Snake River. And it's after all of the big swoop of the Snake goes through all the agricultural plains, and you could, 1, palpably taste the difference in the water, and 2, we would have to move our boats up and down every day because the release is in the dam. And I was like, what is happening here? This is crazy. So that's why I got interested in doing water law. And I think Jan said this is okay. I really sincerely want people to understand more about water because it's such an important thing. And we're going to soon be doing a water law for professionals course at our firm. So if you're an engineer or someone who wants to do something like that, just email me and we'll put you on that list. And it's going to be 3 2-hour lunches where we kind of talk about water stuff. Because everyone has lots of questions, and these are really complicated issues, and they're pressing. And so I think it's really important to get lots of good folks out there thinking about this.
On that score, let me note that 2 weeks from now, we'll have the second talk in this series on Utah water law on the Colorado River crisis or opportunity, delivered by Amy Haas, who's the executive director of the Colorado River Authority, right here at 12:15, sponsored by the Stegner Center, as well as the National Audubon Society. We want to extend our thanks to them for funding for this water law series. And please join me in thanking Emily Lewis for this very informative talk.